Let's talk about some statistics that have been borne out in the news recently. More than 25% of all civil lawsuits filed are employment related. All civil lawsuits filed anywhere. Nearly 75% of all lawsuits filed against businesses are employment related. Employers lose approximately 60% of those cases, the typical award being about $500,000. In fiscal year 2007, there's close to 83,000 EEOC charges filed. Since I prepared for this slide, the number came out for fiscal year 2008. You know what it was? Over 95,000, a 15% increase. Okay, you all know what the EEOC is. That's just the federal claims, right? It's almost impossible to track state claims of discrimination filed in the state agencies or in state courts. So you get an idea of what's going on out there. And most important, individual managers are sued more often today. Recently, another survey indicated that 69% of human resource professionals say that President Obama's policies on employment law will make their job even more difficult. Who remembers the Super Bowl score? Steelers played do you know the Steelers played the Cardinals in the Super Bowl? Okay. How many people remember the score? You remember who won? Okay, Pittsburgh won. I submit to you that the score was not 49-0 for the Cardinals, right? But what I will tell you and what I've translated into my business, the score could have very easily been 49-0 for the Cardinals. How? What if they had the Steelers playbook? What if they knew the plays before they were even run? What if they knew before, just because of how the Steelers lined up, they knew what was coming? They could prepare for it. The Steelers would not have been successful. That's the concept that I bring now to the companies, okay? I share the playbook. I'm going to teach companies now. I teach you, and I hopefully you'll take away some things today through the examples that I'm going to give. How to look at the plaintiff's playbook so that you can better prepare for the attack that will surely come. Bob and Joe is not their real names, but in a case that I had against a major airline, how many of you have companies where employees punch a time clock? Okay, I'm sure part of the policy is that you cannot punch somebody else's time card, right? That's stealing time, right? Discipline up to and including termination, right? Well, in this situation, Bob was my client, and Joe was coming to work a few minutes late that day. He calls my client from the parking lot and says, I'm going to be there in 5 minutes, punch me in. I'm in the parking lot. So, of course, my guy says, no problem. They punched in. According to the policy, they're both guilty of stealing time, right? They both get fired. The termination letter is exact, word for word. All they did was change the name, Bob, Joe, okay? It's exactly the same. You're both fired for stealing time. 2 weeks later, Joe was brought back. He flew to safety. My guy, Bob, he's in jail. He's done. Never brought back. Why? 6 months earlier, he had written a letter to the FAA complaining about compliance issues, safety issues on the planes, not being inspected well enough. Once there's differential treatment like that, if you fail to enforce the policies in a uniform manner, that's differential treatment, that's a credibility issue, and that means what? Jury. That means you get to a jury. The plaintiff is going to get to a jury. You don't want a jury, right? Probationary assessment, right? No problem with having a probationary assessment form. Every company has 60 days, 30 days, 90 days, right? Probationary, everybody evaluates each other, sees if it's a good fit. So why was this a problem? This was a problem because the company had a policy of a 90-day probationary assessment. This person, my client, was hired November 19th, 2002, and the probationary assessment form was completed January 27th, 2003. 68 days. Not even 88 days. Not even close to 90, right? And this person was not successfully completed probation and terminated. So that's not applying the policy of 90-day probation in a uniform manner. Why was this not done in a uniform manner in this case? On January 13th, 2003, my client informed her supervisor that wrote this out that she was pregnant. On January 27th, the same day this was written, she had gone to the affirmative action officer and complained that in those 2 weeks since she told her she was pregnant, she was treated differently. Now, was she treated differently or was she not treated differently? I'm not going to give you those facts because we all, you know, we're going to have different sides on that. But the point is that she did go to affirmative action officer on January 27, 2003, and that day her probation form was completed. 68 days out of the 90, right? This policy was not applied uniformly to her. Easy area of attack. And most cases don't have a smoking gun where it's going to be a slam dunk one way or the other. Attorneys must make their cases with documents that existed before the lawsuit was filed. So you have to keep documentation at all times. Juries will tend to fill in the gaps of any documentation that's missing, or if there is documentation, it may be erroneous. There might be erroneous comments. I'm going to show you some examples. So juries tend to fill in the gaps. Who wants a jury to fill in the gap for them? No, okay? But I had a problem with this because she was terminated for attendance, but the circle is for punctuality, attendance, and appearance. I mean, that circle goes around all three. I don't know what that means. The X for the attendance is between the U and the S. The U is circled, right? I don't know what that means. There's no comments under future goals and plans or employee, no room for the employee comments. Nobody wrote anything. Down here, it says excellent RN, all right? Mixed messages to a plaintiff's attorney. Excellent RN with 1 star, 2 asterisks say try to keep your hours to full time, and she was getting a raise, $1 an hour. There was so much in here to attack that meant erroneous documentation to me, credibility issues to pose this person and just attack them for an hour on this one document at a deposition. Okay? Mistakes like this, erroneous documentation like this, will get you defeated at summary judgment. Everyone knows what summary judgment is? Okay? Summary judgment is a legal term that a company will ask a court to throw the case out and not let it get to a jury because there's no factual disputes. Everything can be decided right by the law. And the company is basically saying to the judge, Judge, look at the law, look at what's happened here, there's no case, let's go home, call it a day. But if there's a factual dispute, judges don't decide facts, juries decide facts, right? If it's a he said, she said, a judge doesn't say, well, I believe her, sexual harassment existed, you lose. It's a factual dispute, that's what a jury decides. When you have erroneous documentation like this, that's a factual dispute. A jury has to decide who to believe when the person filling this out testifies as to what they meant by all those things. And the jury's going to listen to me say, you can't believe any of it because it's so erroneous. There's things all over the place. Okay? Plus, she was terminated a month after she cared for her mother who had cancer. Right? Erroneous documentation like that will get you to a jury. You don't want a jury. The next topic, area of attack, performance review puffery. Does everyone know what I mean by this? Managers often inflate ratings to spare bad feelings. It's difficult to later claim poor performance. Credibility is key. I can't tell you how many times I've sat across from a deposition from somebody that completed a review that is golden. It looks great, but yet the person was fired for poor performance. And I say, well, how could you write this? And what do they say? Anybody want to tell me? Right. You don't want to hurt the feelings. That's number one. And the second most popular thing is, at our company, we're very different than every other company. We keep everything positive. We like high energy, positive energy. So I thought I would put in the review what my expectations were because I thought that might motivate the employee. You're scratching your head, right? It doesn't make sense. The performance review, in order to be effective, must be accurate and truthful. And before I take questions, I'm going to ask you, what is the one question that none of us want to hear? I've referenced it a lot during the course of the seminar today. What's the one question none of us want to hear? Has the jury reached a verdict? You do not want a jury, right? Okay? You do not want to be sitting there when the judge says, has the jury reached a verdict?